You, Wallace, for inviting me. A good evening from Sydney. I'm usually based in Thailand, but just because of timing, I just happened to be in Australia this week. Um, the Rohingya have been subjected to genocidal situation for a very long time. In 2006, ASEAN Burma, my organization, published a report analyzing the situation of the Rohingya in the context of the Convention for the Prevention and Punishment of Genocide. And we found, unfortunately, that the treatment, the systematic discrimination against Rohingya constituted a slow burning genocide. That slow burning situation worsened since 2012 and culminated in 2016, 2017 in what is commonly recognized as the genocide of the Rohingya. Now, in February 2021, the military of Burma, Myanmar, started a coup. They have, it's an attempted coup. They haven't actually won it yet. And we hope, and we don't think they will win it. But it has escalated conflict throughout the country. And in this situation, put the Rohingya in a worse situation. So in the past 3.5 years, there's been 35,000 incidents of armed clashes and attacks against civilians. This actually averages out to between 800 to 900 incidents per month in the whole country. And what we've seen is that the resistance, both the peaceful, the political, and the armed resistance has grown throughout the country to resist the illegal junta. And the Special Advisory Council of Myanmar has already acknowledged that the majority of the territory of Burma, Myanmar is now under control of the resistance forces, but the military junta controls many of the main population centers where 67% of the population is located. Already, nearly 3 million people have been displaced because of the violence, and the junta troops have increased their crimes with more intensity. As the authorities, as the resistance and the elected government continue to increase the territory that they control, the junta's troops are unable to move safely throughout the country, and the military junta has resorted to airstrikes, mainly targeting places of worship like churches, Buddhist monasteries, and mosques, as well as schools and hospitals and camps where internally displaced people are sheltering. And this is part of the problem that the military has traditionally had a strategy of attacking civilians in order to overcome their opposition. So it's important to note that between January to September last year, the largest number of civilians killed by airstrike in the world was in Burma, Myanmar. Of course, this terrible situation became much worse when the Netanyahu regime started launching airstrikes on Gaza, and we are absolutely shocked and distressed, and extend our solidarity to Palestinians about what the kind of atrocities and war crimes that they're facing, because this has been also a routine practice by the military in Burma, Myanmar. Now, what has happened is that as the military junta loses troops, many of them defected to the resistance in order to fight their former employers. The junta activated an old law to forcibly conscript young people, both men and women, aged 18 to 35, and force them to join the army. This has happened since February this year. And in this situation, as the armed conflict gets worse in Arakan or Rakhine State, the junta, the military, who traditionally denied the identity and the indigenous status of the Rohingya people, in fact, called them illegal foreigners and so on, refused to and took away their citizenship. They are now, um, they are now. Sorry, Hannah, I think you're speaking. So they are now grabbing young people, Rohingya people, from the internally displaced camps. They are now grabbing young Rohingya men from the internally displaced camps and forcing them to work to fight in the military against the resistance forces. So what we are now seeing is that Rohingya young people who are stuck in Burma in the camps are now being grabbed by both sides, the Arakan army, the mainly Rakhine fighting force, and the illegal junta, and being forced to fight against each other. And what we've also seen is a rise of hate speech and hatred against Rohingya, accusing them of being traitors and siding with the military junta. Very disturbingly, last month, we've seen the Arakan army burn down Buridown, the city of Buridown, where the majority of the population are Rohingya, and between 150,000 to 300,000 Rohingya have been displaced in that one incident. So, and those Rohingya who are sheltering were able to reach Bangladesh in Cox's Bazar and sheltering in the camps where Turkey has had a very big and significant humanitarian presence. We've seen that almost 500 young people were abducted from these camps by armed groups last month. And it is suspected that they were forced to go back to Burma, Myanmar to fight for the military. So we are facing this situation of forced conscription. Young men all over the country are being forced into the army, but the Rohingya are particularly vulnerable and being forced in a situation where they have been forced to join both sides of the conflict against their will, and are being hated and targeted for the same reasons. So now we see this hugely terrible situation. The Rohingya are now even more at threat. Throughout the region, we also see a very coordinated online hate campaign against the Rohingya for the past 2 to 3 years, including in Malaysia, Indonesia, and India. And what that means is that Achenese people who were in the northern part of Indonesia who were welcoming Rohingya boat people, some parts of those communities are now being turned into violent resistance or violent opposition against the Rohingya, where refugees, boat people who just arrived in Aceh, Rohingya boat people, mainly women and children, are being threatened with violence and trying by a small group of local people trying to chase them away from Indonesia. Similarly, in Malaysia, we are facing a critical situation where there has been criminalization of the Rohingya, where Malaysia was on the verge of deporting Rohingya back into the war zone in Burma, Myanmar. And when there was a pushback or objection to this, we saw that many of the Rohingya who were arrested by Malaysian immigration, including women and children, are now being forced into indefinite detention. That means they are detained with no charge and they've been forced to stay in detention without any end in sight. So it's very clear that access to justice for the Rohingya needs to happen, and that justice also needs to understand that civilian protection of the Rohingya, whether they are in Burma, Myanmar, or whether they are in host countries seeking asylum, is the most important issue now. Um, and I hope that our friends in Turkey will understand this and use the significant influence they have in this region, particularly with Bangladesh, India, Indonesia, and Malaysia, and Thailand, to ensure protection for the Rohingya in this time where their safety is the most at risk. Thank you.
Thank you for that. Debbie, if I could just use my position to ask you a question, if you could just tell, the viewers just a little bit more about why, despite, the civil wars being fought by other ethnic minorities, just a little bit more about that, and why the Rohingya are still seen as different to those minorities that are fighting. Thank you.
Thank you, Shabnan. Yeah, it's important to understand that for many decades, there were several ethnic organizations, political and their armed wings, fighting a resistance against successive military regimes of Burma, Myanmar, mainly because they have been prevented from participating in the political life of the country. So they've been excluded from politics. They've been excluded. They've been wanting to have peace agreements, and these peace agreements were denied by the military. Only ceasefires that the military often violated. So when the coup happened, what we saw was the ethnic Burmans, the elected parliamentarians who were elected at the end of 2020 in the general election, as well as the ethnic groups teaming up. And this is why we've seen such massive victories in the country. But in this picture too, the Rohingya have been consistently vilified and excluded. And that was part of a very systematic dismantling of the legal protections and the legal equality of Rohingya. We have to understand that Rohingya were a recognized group in the country and enjoyed full citizenship rights. And that was taken away from them in 1982. It's also important to note that successive military regimes were able were successful in their hate campaigns against the Rohingya to turn public sympathy away from the Rohingya and make the population, the mostly Buddhist population, feel paranoid and afraid of the Rohingya. Rohingya, it's quite shocking when you see that the Rohingya was subjected to some of the worst atrocity crimes, and they were subjected to genocide. But when you talk to some of the Rakhine people and other mainstream communities in Burma, we were shocked to find that they were terrified of the Rohingya. They were almost neurotic about the Rohingya because they had been subjected to decades of propaganda from the military. And the military wanted to do that so that they can tell the main population, even if you hate us, you need us because we are the only ones protecting you from the Rohingya. So they really demonized the Rohingya, and it's only after the coup started in 2021 when other communities started to see for themselves and experience the same similar atrocities that the Rohingya suffered for so many years, that their eyes were open and the younger generation of activists actually apologized and understood what was happening. So there was this a glimmer of hope that the inclusion of the Rohingya in the democracy movement is possible. But what we've also seen is that the hatred campaign against the Rohingya, saying that they are now fighting on behalf of the junta and are traitors to the cause, is also undermining some of that in principle support. So we really need to work hard now to turn back the tide of hate against Rohingya, while at the same time insisting that they must be given civilian protection wherever they are. I hope that helps.
Thank you.
Thanks, Shana.
Thank you so much. Thank you, Debbie, for that. We're now going to go to our next panelist, Natalie Brinham, and she is an Economic and Social Research Council postdoctoral fellow at the University of Bristol in the UK. Her work is focused on statelessness, ID systems, and genocide. She has a PhD in legal studies from Queen Mary University of London, and her thesis focused on the identity destruction and the Rohingya genocide in Myanmar. She also worked for many years in human rights NGOs on the issues of forced migration and trafficking. And today she's going to speak to us about Rohingya identity and also consider the issues of legal genocide and apartheid. Natalie, there's also a question that maybe you can incorporate where one of the listeners is asking about the terms of Burma versus Myanmar, Rohingya versus Arakan, and the political stance behind these choices. So if you could also incorporate that. Thank you very much for being with us today.
Thank you, Shabnam, and thanks, Debbie, for a great introduction to the issues. As Shabnam said to you, I was originally asked to talk about Rohingya identity and then asked to give it a legal angle. So if you mesh the two together, you get legal identity. So today I'm just going to provide some background to the situation for Rohingya in Myanmar, focusing on legal identity and the lack of legal identity. So firstly, I understand that most of you have a common concern about the crimes that are being perpetrated against Palestinians. I'm not an expert on Palestine, but I am sure as I speak about the situation for Rohingyas, you will probably be able to draw many parallels between the two situations. Not least the structures of apartheid, the conditions of genocide, and the weaponization of the citizenship regime and ID systems to prevent return and to permanently remove the ethnic and religious other from their homelands. So the Rohingya homelands are on the edge of the Bay of Bengal, which is today in Myanmar, which was known as Burma under British rule. And I'll say a little bit more about that. But even before the British colonial period, that area in the Bay of Bengal was characterized by international trade, the exchange not only of commodities, but also ideas, arts, cultural practices, and the exchange of people as well. So in other words, it was a hub of diversity. And the rivers and the sea served as the main trade route for people who moved across what are today national borders. And this includes the Rohingya and the ethnic Rakhine, who are the predominantly Buddhist majority group in the area today. It was also an area of conflict and forced migration even before the British arrived, and even before the Japanese occupation during World War II. So the idea that Rakhine, where the Rohingya homelands are, is made up of an indigenous Buddhist population and a migrant Muslim population is quite simply an ethno-nationalist fantasy and a fallacy that unfortunately gained a lot of traction, particularly domestically. So on gaining independence from the British in 1948, Myanmar or Burma had the difficult task of putting together a state from the people and places that had been devastated by years of colonial oppression, divide and rule strategies, and engulfed by some of the fiercest fighting of World War II. So providing citizenship on independence was a way to strategically embrace multiple ethnic groups, some of whom have been fighting against one another. It was, if you like, a kind of promise of peace. And when the citizenship rule and the constitution were developed in the early years of independence, they largely hit a balance in the way that citizenship was acquired. So citizenship was based on indigeneity, but also on parentage, on length of residence, on marriage, on birth on the territory, and on loyalty and other aspects that were common to citizenship regimes all around the world, excuse me. So Rohingya, as Debbie underlined as well, Rohingya are emphatic in saying that they were provided the same citizenship rights and the same IDs as all other citizens in the early years of independence. They could move and live anywhere in the country and enjoy all the other rights associated with citizenship. From 1962, a military junta ran the country. Things changed slowly for the Rohingyas and for others who were perceived to have South Asian or colonial connections. Just as we have seen in Palestine, where censuses and citizenship rules have been used in the immediate aftermath of mass expulsions to deny people the right to live in their homelands, so too were the citizenship rules, ID systems and censuses misused in similar contexts in Myanmar. And that's what I'm going to explain a little bit about now. So 1978 saw the first wave of mass expulsions of Rohingya into neighboring Bangladesh. Roughly 250,000 fled. What was supposedly an immigration operation turned into a terror campaign. Most of the refugees were forcibly returned to Myanmar by Bangladesh within about a year. So essentially, the Myanmar military's attempt at ethnic cleansing at that point had failed. Following this, a new citizenship law was enacted in 1982, which can be seen as a sort of fresh attempt to do the same thing. Essentially, it stripped back the provisions for acquiring citizenship or nationality through multiple balanced means and based access to citizenship almost entirely on membership of an official ethnic group. There are other routes, but the application, in the application, the evidentiary threshold for citizenship are very prohibitive, and most Rohingya and many others cannot meet the criteria. The national ethnic groups, importantly, the list of the official groups was decided entirely at the discretion of the state in an opaque process which left the Rohingya out, as well as some other groups. So the ID system for this new law, which was color-coded, wasn't rolled out until 1989, and shortly after that. It was at this point that many Rohingya realized that they weren't recognized by the state as citizens. The early 1990s saw another round of mass expulsions into Bangladesh and terror campaigns, and approximately 250,000 fled again, only to be forcibly repatriated within a couple of years again. So you can imagine their status whilst being out of the country is also diminished. So it was during this period in the mid-1990s where the ID and citizenship regime was used to create a system of segregation and apartheid. Rohingya were issued a white card or temporary registration card, which was different from other citizens and which kind of permanently cemented a kind of non-citizenship. On the basis of these cards, they were confined to small geographic pockets of Rakhine State, and their freedom of movement was severely restricted. Then a new hybrid security force came in, which was known as Nasaka, and it was developed only for the Rohingya and had a whole surveillance system of its own. So a web of checkpoints surveillance and restrictive bureaucracy was brought in, meaning that Rohingya white card holders had to apply for permission to do almost everything, from moving between village tracts to going about their livelihoods to repairing their houses and properties. And of course, this also enabled a system of extortion and harassment. Local orders, many of them only verbal and not written down, meant that Rohingya was subjected to a whole host of local policies and practices that applied only to them. And this was included for things like ways of obtaining marriage permission and limitation of births. The most important registration document that proved permanent residency in Myanmar was a family list. And during both routine and spot checks, Rohingya who weren't at home could be struck off the family list with the stroke of a pen. This effectively meant that they had, after they were struck off, they had no right to live or return to Myanmar. So they were sent into permanent exile, essentially. So according to Amnesty International report, this system within the Rohingya areas has 5 features of apartheid. That is the denial of the right to nationality, extreme restrictions on freedom of movement, wide-ranging violations of economic and social rights, including health, education, and livelihoods, and systematic social and political exclusions. There were further rounds of pogroms and mass violence perpetrated both by state actors and by local Buddhist nationalists. This time during the decade-long period of a hybrid military-civilian rule. In 2012 and 2013, there was more conflict and mass forced displacement, leading to more segregation and containment, this time in IDP camps. So many Rohingya and other Muslims from Rakhine State are still confined to these IDP camps today and have permanently lost their access to land. So within this context of displacement and conflict, another new ID card was brought in for the Rohingyas, which was known as the National Verification Card. And this card effectively labelled Rohingyas as foreigners who needed to have their nationality verified. So, of course, this was met with a lot of resistance from the Rohingya, and the authorities, including the military, tried to enforce the ID system, which led to increasing securitization and increasing presence of different authorities in Rohingya areas. The ID system was misused, whereby ID cards and the lack of ID cards was used to deny access to food, healthcare, education, livelihoods, and various other aspects of normal everyday life. These methods, according to different human rights investigators and bodies, met the threshold for several acts of genocide, including causing serious bodily or mental harm and imposing living conditions intended to destroy the group and preventing births. This was the context when the 2017 so-called clearance operations or genocidal violence occurred that involved mass killings, mass rape, destruction of whole communities, and sent 750,000 Rohingya fleeing into Bangladesh. In 2021, as Debbie mentioned, and I won't go into this in detail because she's covered it very well, there was a military coup in Myanmar, and one of the many military strategies that has been used on the Rohingya and other ethnic minorities are now being used on large swathes of the population. The Arakan army, so Arakan being, you can use it essentially interchangeably with the word Rakhine. So the Arakan army, which is made up of ethnic Rakhine Buddhist nationalists vying for self-determination, claim to have control over most of the territory in Rakhine State now, including the Rohingya areas. And sadly, from Rohingya reports, the patterns of discrimination and persecution continue under both of these parallel state structures, with the Arakan army imposing their own administration rules and judicial system, and with the forced conscription, as Debbie talked about, into different warring military forces. And there's reportedly massacres of Rohingyas on both sides. So currently there's so many barriers to accountability for these crimes, not least because these are de facto state authorities, which obscures the mechanisms of accountability. Also, access in and out of the region has been cut off, making documentation of crimes very challenging. So I am going to stop here with this overview of the legal landscape. And I am sure that others will have a lot to add on the context. Just to go back to the question in the chat about the politicization of the term Burma and Myanmar. So Burma was they're actually from the same root, Burma, Myanmar. Burma was used by the British. And so in a sort of move to rename different places, including the name of the country under the military regime, it was renamed Myanmar. For many years, people contested this term, the political opposition preferring to use the old term Burma, and the words Arakan and Rakhine similarly were used for different sort of political with different political connotations, let's say. I think it's probably safe to say that in today's context, Arakan and Rakhine, which are also from the same roots, as is the word Rohingya, from the same roots for the same place, can be sort of used interchangeably. So it's not too confusing, just to know there's some politics behind it. Thanks.
Thank you, Natalie. Natalie, there's one more question for you in the chat. And it says that at some point you made a distinction between indigenous Buddhists and migrant Muslims. Doesn't this reinforce the Myanmar apartheid, well, the apartheid of the Myanmar regime?
Sorry if I wasn't clear there. What I was saying is that this division has been created, and it is most definitely not true. It was a heterogeneous population, and in the building of an anti-colonial and anti-South Asian state, they have drawn on this idea that Rohingya, because they look different or because they speak differently, are therefore migrants from Bangladesh because they share some cultural affiliations. That's not the case. They're just as indigenous as the Rakhine populations there.
Thank you very much. And thank you for laying that foundation around the various identity issues that the Rohingya face. So the next panelist that we're going to be hearing is Tung Kin. Tung Kin, for all of us who watch the news on TV, is probably a very well-known face. He's a Rohingya activist and the co-founder and president of the Burmese Rohingya organization in the UK. And over the years, he's been a leading voice for Rohingya. He was actually born and raised in Arakan state, and his grandfather was a parliamentary secretary and deputy minister during the democratic period of Burma in the 1950s, and his grandfather was the first judge in Northern Arakan state. He actually is a graduate of civil engineering, and he has briefed all sorts of officials and parliaments on the Rohingya situation. But most importantly for today's talk, Tung Kin has brought a universal jurisdiction case along with his team in the Argentinian courts. And of course, you know, the ICC matters and the ICJ matters are there, but going to national jurisdictions is so important for relief because it's one more step we can make, you know, to make the world smaller for war criminals. So today, Tung Kin is going to be sharing with us his reflections and his insights around the case that him and his team are bringing in Argentina. Tung Kin, it's over to you.
First of all, thank you, Shabnam, having me here. And it's very important event and timely what the situation of Rohingya is really getting worse day by day in our current state as we are witnessing right now. And let me bring you first that about the case. And on the 25th August 2017, the state of Rakhine in Myanmar, a genocide which was already ongoing, was finally carried out against the Rohingya people. The intention was to partially to destroy us as an ethnic and religious minority, and perpetrators succeeded. The truth about this genocide cannot be contested. I want to repeat again, the truth about Rohingya genocide cannot be contested, but we are determined to seek justice. The criminals who ordered and executed the genocide have to be accountable, accomplices as well. We will never give up until justice against perpetrators is done. We will go wherever our plight for justice is heard. Our lives are struggle, are tough. Survivors with both in the refugee camp, those who continue to live in Myanmar, bear the worst part. But we are convinced that out of this genocide, our community will grow stronger in dignity, and we will consolidate as respected members of humanity. Let me bring you Argentina case, which is a part of our determination. In December 2019, our organization, Burmese Rohingya Organization UK, and our attorney, Thomas Cantana, we filed a complaint in Argentina court seeking justice for the Rohingya genocide under the principle of universal jurisdiction. The complaint refers to the period 2012 to 2017 in Rakhine State and mentioned both military and civilian perpetrators. It relies on the 2018, you all know that about UN fact-finding missions for Myanmar reports on subsequent Human Rights Council resolution, which call for accountability values. You all know that Argentina has a long experience in addressing accountability for its own crimes against humanity during the 70s. It has been internationally recognized since then as a fervent defender of human rights. Under this framework, the courts have developed the principle of universal jurisdiction in practice, and a number of criminal investigation has been processed in the last years now on Myanmar. In this respect, executive branch has recognized the validity of universal jurisdiction principle. Myanmar complaint was in principle dismissed by Argentina courts based on three issues. When we first submitted, they saying that it was already being investigated at the prosecutors of ICC, and then they say in Myanmar that in the future Myanmar, like Argentina, might offer impartial and independent tribunal to address accountability. Third, they say Argentina and Myanmar have no cultural connection. At the appeal court, we distinguish between the crimes investigated ICC and the crimes what our organization brought complaint. And second, we reported that UN in general has concluded that Myanmar does not have independent judiciary capable of guaranteeing fair justice. And finally, we couldn't accept the lack of cultural connection is a barrier to legitimate universal reaction at the most serious international crimes. The appeal court gave reason to our arguments, and December 29, 2021, it ordered to open the investigation of the Rohingya genocide. The application of universal jurisdiction in Argentina does not require the presence in its territory of either the victim or perpetrator. Let me explain to you about the investigation. Investigation has been assigned to a prosecutor. Brooke and 6 survivors had become private party in the procedure. When I mention about 6 survivors, there is the women from the camp who faced serious horrific crimes by the Burmese military in 2017 August. For investigation purpose, we encourage both prosecutor and independent investigative mechanism to engage each other. They have been interacting since then. The court first took my testimony, that about what I have seen during my time in Arkhane State. I left when I was 17 from my country, and I was witness what's happening to the Rohingya. restriction of movement and marriage, and restriction on marriage, restriction on education. Those what I have witnessed for myself. Even I couldn't go to the university, even though my grandfather was a member of parliament. My father did government service more than 20 years, because this is systematically destroying our community. I've been highlighted on that, my testimonies. And also we requested testimonies of, survivors from the Cox's Bazar camp in Bangladesh, who made extraordinary and historic journey to Argentina with the help of Legal Action Worldwide. In June 2023, last year, 1 man and 6 women gave in-person testimony at the courtroom in Buenos Aires. We also offered additional visual testimony. The environment is totally different. Let me explain about it. These women, they traveled 40 hours from Cox's Bazar to Buenos Aires. I mean, their journey, which is justice journey, they never took a flight. I have seen from their eyes and from their face how they can see a kind of what justice looks like. And they were sitting in front of the judge, in front of prosecutor, in one courtroom. The first time Rohingya women were able to testify at the court of law. And one of my sister told me, brother, this is very exciting moment for us. We are suffering many days, many years in Rakhine State. We never get a chance to talk what's happened to us. But today we are able to give this testimony, this what's happened to our community, myself, that I have never thought it. And that's what they describe it. So also, in addition, we also decided at the court the role of Facebook in the spread of hate speech during the time of clearance operation. In this respect, the court issued official rogatory letter to US government under Inter-American Convention on Mutual Assistance in Criminal Matters, requested all Facebook information regarding the dissemination of the hate speech and incitement of violence towards Rohingya community. US responded that the request did not comply with local regulation. A new request under those terms is going to be processed. The court also incorporated to the file the US Secretary of State determination of genocide against Rohingya, which had been requested by the court. So what are next steps for the case? In our legal opinion, the evidence existing in the file at the moment proves prima facie the genocide and atrocities committed against the Rohingya in Myanmar in August 2017, indiscriminate killings, including infants by fire or stabbing, torture on the spot, simultaneous gang rape of women, looting and torching of the village, and forced disappearance of villagers and other felonies. Furthermore, the evidence also indicates the identities of those responsible of the genocide and crimes against humanity committed. Based on this assessment, in December 2023, last year, I traveled to Buenos Aires and submitted arrest warrant request against 7 perpetrators. The court took note of the petition and decided that it will consider it in the future after additional investigation measures are completed. In case international arrest warrant are ordered, we request that notification is sent to Interpol, to the UN, ASEAN, EU, OIC, African Union, and to single state that impose targeted sanctions such as US, Canada, and UK. Investigation will continue, and new Rohingya survivors can give testimony to the prosecutor to determine crimes committed in other areas of Rakhine State. Additionally, a complaint for crimes against other minorities or civilians can be considered in due course. And whenever we talk about this case and whenever we talk about justice, one thing I want to point out here that we are, of course, Rohingyas are leading this case, but for the justice is not only for the Rohingya, for all the people of Burma, our brothers and sisters. Every day, who are facing war crimes and crimes against humanity by Burmese military, those justice will be brought to everyone because we are fighting common enemy. And together, the case will make us stronger. And, these cases, even the Rohingya case, together, this justice will be for everyone. That's what we're looking at. Also, I want to point out currently the situation, not only military, Arakan army is targeting Rohingya people in Arakan state. You may all have know that at least 200,000 Rohingya become IDPs. Arakan army systematically burned down many houses, thousands of Rohingya houses, and a dozen of villages burned by Arakan army. What's happened in last May? And many people are facing humanitarian aid, blockade, and really in danger. Many Rohingyas in Arakan state right now. No matter who is it, we have to work out to get justice, and we have to work on accountability. Whenever we talk about inclusive future federal union of Burma, we looking ahead a country that respect identity, their dignity, respecting human rights each other, and equality in Rakhine State. So that is very important. We look forward to work on these accountability issues, not only this case, and more cases we will work on in future. But in Burma, no matter whoever committed these crimes, war crimes, crimes against humanity, and genocide, we have to work steadfast to bring those responsible to justice. I stop here. Thank you.
Thank you so much, Tunken, for that overview of the case. And it's we've been following it, and it's really amazing, especially that the woman went from the camp and gave the evidence. What an amazing gesture. And our last speaker this afternoon, before we go to some questions, is Henna Zuberi, who is the Director of Advocacy at Justice for All, which is a human rights organization working against genocide. She is also, they work on the Rohingya, they work on Uyghurs, they also work on Kashmiris, Indian Muslims, Palestinians. Henna herself is a journalist, and she anchors the Daily Muslim News and hosts Justice for All Now show, a talk show on peace and justice on the Muslim Network TV. And for over a decade, she's written for and run Muslim Matters, an online Islamic magazine read the world over as the editor-in-chief. Henna has worked as a television news reporter and producer for CNBC Asia and World Television News. Best of all, she says she is a mother of 4 of the most wonderful people in the world whom she has had the honor of parenting and unschooling. So Henna's organization is one of the driving forces behind the ICJ and supporting forces behind the ICJ case. And today, Henna is here to tell us more about the case and share her reflections on it. Thank you for being with us, Henna.
Thank you so much, Samaikom, for having me. It's such an honor and a privilege. And so today we're going to explore this profoundly significant case before the ICJ, the International Court of Justice, the Gambia versus Myanmar concerning the genocide against the Rohingya people. And this case is rooted in the principles of international law and human rights, and not only seeks justice for the Rohingya, but also tests the very fabric of our global commitment to preventing and punishing acts of genocide. And we see this, how important this is, especially in the context of Israel and Palestine. Our discussion today, I will want to touch on the legal arguments and the compelling evidence and the broader implications of this case. I also want to touch on the motivations behind the Gambia's courageous decision. It's a very small country, not very powerful, to bring this case forward. And so let's begin. So as you all have already heard, the background of the Rohingya genocide was predominantly Muslim, ethnic minority, indigenous people in Burma, and the systematic discrimination and violence against the Rohingya, including the 2017 massacres, which impacted and we saw thousands of people being killed, babies burnt alive, and over 750,000 Rohingya forced to flee to neighboring Bangladesh. And we have been, as a genocide prevention organization, had been calling it a genocide for a long, long time, a slow burning genocide. We have been speaking to the US government, our State Department, congressional offices, beating the drums and calling their attention to what was happening in the region much before 2017. But unfortunately, as it is in these cases, many of our government officials did not take it as seriously until they saw the mass exodus. So the concept behind the case is based on the Convention on the Prevention and Punishment of Crime of Genocide, adopted in 1948. The primary allegations is that Burma's military conducted acts of genocide against the Rohingya, including killing, causing serious bodily harm, and deliberately inflicting conditions of life calculated to bring physical destruction. The Gambia, as a member of the Organization of Islamic Cooperation, the OIC, filed the case on behalf of the broader international community. The Role for Justice for All's Burma Task Force, we have specific projects, and the projects that Justice for All ran for the Rohingya and still runs is the Burma Task Force. We were on the ground in 2017. Our team was on the ground and collected crucial evidence and testimonies from people as they were coming into Cox's Bazar. And what the impact on the case has been that these testimonies provided vital firsthand accounts used in the ICJ proceedings to support the genocide claims. And so in November of 11th, 2019, Gambia filed the case. On January 23rd, 2020, the ICJ ordered Burma to prevent acts of genocide and preserve evidence and report on measures taken. The Gambia submitted its memorial on October 23rd of 2020. And this document was crucial as it provided a comprehensive statement of the facts, legal arguments, and evidence supporting the claims of genocide against Myanmar. It laid out in detail how Myanmar's actions against the Rohingya constituted breaches of the Genocide Convention. Myanmar filed its counter memorial on August 24th, 2023. This document serves as their formal response to the allegations made by the Gambia. It includes Myanmar's rebuttal to the genocide claims, presenting their own versions of the fact and legal arguments in an attempt to counter the Gambia's accusations. And these are foundational documents in the ICJ proceedings that allow each party to fully present their case and responses in writing. And these submissions are essential for the court's understanding and provide a structured basis of the oral arguments that follow. So in the early stages of the proceeding, Myanmar raised preliminary objections to the jurisdiction of the International Court of Justice and the admissibility of the case brought by the Gambia. Myanmar argued that the ICJ lacked the authority to hear the case and that the Gambia did not have the understanding to bring forward the claims that it had. And they contended that the issues at hand were matters of Myanmar's internal affairs and should not be adjudicated by an international tribunal. However, and with the help, and I did want to mention that the US law firm Foley Hogue helped the Gambia secure this unanimous binding order from the International Court of Justice to prevent further genocide against Rohingya in Myanmar, Burma. And so in a historic decision on January 23rd, 2020, the court approved provisional measures requested by the Gambia and rejected Burma's request to dismiss the case. The ICJ agreed that the Rohingya in Burma are at risk of ongoing genocidal acts and they need urgent protection. The court ordered Myanmar to prevent all acts of genocide preserve evidence, and to report back on compliance. These orders are binding under international law. Foley Hoag's team led the legal team, included its partners, and particularly I'll point out Arsalan Suleiman, who used to be a part of the OIC, amongst others, prominent international human rights lawyer like Professor Philip Sands and Professor Payam Akavan and Jessica Jones were also part of the team. And Philip Sands actually said in an op-ed in The Guardian that the ICJ ruling sends a clear message that no state can evade international scrutiny when serious allegations of genocide are at stake. This decision is a significant affirmation of the court's role in upholding international justice. I did want to also point out what the current status of the case is. So there have been interventions by other states: Canada, Denmark, France, Germany, the Netherlands, the UK, and the Maldives have filed declarations of intervention under Article 63 of the ICJ statute. And the reason for the intervention these states have given, they're all party to the Genocide Convention and have expressed a common interest in ensuring the proper interpretation and application. Maldives' position was even more stronger. They expressed deep concern over the ongoing human rights violations against the Rohingya most recently, and emphasized the need for international cooperation to prevent and punish genocide. And I have met with Abu Bakr Tambadou, the Attorney General and Minister of Justice of the Gambia, who brought this case forward, and such an inspirational man and really understanding of what justice means in today's world. His speech that he gave as he accepted our Torch of Justice Award is something that I believe all law students should listen to, especially those who come from a Muslim background. His decision, he said, to take on this case was driven by a moral imperative to act against injustice. Tambadou had previously worked with the UN International Criminal Tribunal for Rwanda and was profoundly moved by the plight of the Rohingya after visiting the refugee camps in Bangladesh. And he saw so many parallels from the case in Rwanda and the Rohingya case. He emphasized that the global community has a responsibility to prevent and punish genocide, and the Gambia, despite its small size, chose to act on this responsibility. I'm going to just also, there were some interesting things that happened during this case. One was the role of Aung San Suu Kyi. The Nobel laureate and Burma's then state counselor defended Myanmar at the ICJ in December 2019. She denied genocide allegations and claimed that the military operations were legitimate counterterrorism. And here we see how the war on terror played out in the Rohingya context, and that these were legitimate measures against the Rohingya militants. I think the babies, the mothers of those babies that were burnt alive beg to differ. International reaction was swift. Her defense received significant international backlash, severely tarnishing her global reputation as a human rights icon. And the evidence in this case, this was the most satellite documented genocide prior to the current Gaza genocide. This was the most documented genocide in the history of our world, and human rights organizations such as Amnesty International, Human Rights Watch, and others documented mass graves, burnt villages, and consistent patterns of violence, reinforcing the genocidal claim. There were interesting legal aspects too that I'm sure all of you would be interested in learning about, that the ICJ order for Myanmar to take provisional measures is legally binding, as I mentioned before, and it highlights the court's authority in matters of international human rights violations. And then Article 9, I believe, of the Genocide Convention, Gambia's invocation of this article underscores the universal jurisdiction principle, allowing any state party of the Genocide Convention to hold others accountable for breaches. And then we saw South Africa do this as well in the Palestine case. We believe that this case is pivotal in establishing a robust legal precedent for holding states accountable. Historically, international jurisprudence has been seen landmark cases such as the prosecutor versus Jean-Paul Akayesu before the ICTR, which was the first to define acts of genocide under the 1948 Convention. The Gambia versus Myanmar will reinforce and potentially expand the boundaries of state responsibility for preventing and punishing genocide. And the court's ruling could set a transformative precedent, not unlike the Nuremberg trials, where individuals were held accountable for crimes against humanity. So we aim to hold an entire state apparatus accountable, affirming that no entity is above international law. And you saw a broad coalition of states intervening in this case. The solidarity is reminiscent of the collective response seen in the Rome Statute creation, establishing the ICC as a permanent body to prosecute the most internationally serious international crimes. So in conclusion, I would like to underscore the critical importance of continued international support and vigilance in this case. It's not over yet. The Gambia's pursuit of justice for Rohingya through the ICJ is not just a legal battle, it's a profound moral and ethical imperative. The Rohingya have suffered unimaginable atrocities, and it's our collective responsibility to ensure that justice is served. And evidence presented, including first-hand testimonies and documented reports of violence, underscore the severity of the crimes committed. These voices must be heard and their suffering must be acknowledged and addressed through proper legal channels. So wherever, like Tunkin's case, this is applicable, we urge people to take on these cases. And I urge all members of the international community, especially legal professionals, to remain vigilant and actively support efforts to bring justice to the Rohingya. And I want to thank all of you for your time and attention.
So we want to thank the panelists today. If there are any questions, we can take them now. Oh, Henna, there seems to be a question here around whether the issue, the fact that Myanmar is not complying has come before the ICJ again, like South Africa went forward to say that the provisional measures are not being adhered to. It's muted, sorry.
About that. I do not believe that they have gone back again, and this is something that I can follow up on and convey that to you. And before the UN Security Council. So this is also something that I do not believe has been brought up before the UN Security Council. Correct me if I'm wrong.
There have been briefings in recent years, and especially since the coup, and there have been calls. There's also been sanctions against countries selling jet fuel to Myanmar, because of course, if we could stop that, you could stop the airstrikes, and countries have responded to that by then putting sanctions on companies that have done that. Of course, the Security Council is slow to act. Unfortunately, the Russian and Chinese veto has been very strong in favor of Myanmar. And so that's where it stands right now. I want to use this opportunity to thank the panelists for sharing their insights and their time with us this afternoon. Also to Wolas for hosting this event. And I want to remind everyone that's joined us that this Thursday would be our 11th annual #Black for Rohingya, where we ask people across the world to wear black, share their messages of solidarity across social media platforms. This year, our focus for hashtag Black for Rohingya is the forced conscription of Rohingya that has been happening over the past few months in Rakhine State. And the reality is genocide is such a huge crime. And it's easy for us to keep saying, well, what can one person do? And I hope that your answer to that is always that everyone can do something. And you can all start off by joining us on Thursday on our solidarity campaign. And thank you very much. And if anyone else from the panel would like to get some closing remarks in, please do unmute yourselves and share those with us. Perhaps we can start with Tumken.
Yes, I want to highlight that Rohingya have been facing genocide many decades. And, currently it's been under military regime for many years. And 2017 international community well aware about through international medias and policymakers, they knew that, and it failed to act in UN Security Council. And unfortunately, 7 years coming up now, these genocide survivors in Bangladesh camp. US been declared genocide. We haven't seen that a stronger action to protect this community. We have seen ICJ provisional measures, 23rd of January 2020. It's been like 4 years, and still Rohingyas targeted by military, now again by Arkan army. And it is very important that a community facing genocide for many decades, currently, right now, they are facing genocide, crimes against humanity. This is important that protection of Rohingya community is urgently needed. Where we are witnessing right now, 200,000 Rohingyas IDPs happen under control of Arkan army. And of course, 120,000 in situ IDP camps for 10 years. On top of that, genocide is ongoing. So 600,000 Rohingya, their lives are at risk. This is very important. When we talk about repatriation, we need to focus on protection of Rohingya who are living in Rakhine State and international community. Of course, we appreciate humanitarian aid support and others. We need a solution, we need a protection. That, of course, justice and accountability, that is also important. Same time, when we working hard for justice and accountability, same time, urgent protection and, repatriation is also we need to look at. To rebuild the community, it is very important. I stop here. Thank you.
Thank you. Debbie, if I can hand over to you now.
I know for many people, understanding and learning about the Rohingya situation seems to be so overwhelming because it is so serious. However, we have seen that the situation can change. Attitudes in Burma amongst Burmans mainly are changing, and everybody can do something. So they, don't feel overwhelmed. Everybody has a role in halting the Rohingya genocide and genocides around the world, whether it's in Palestine, whether it's Rohingya, whether it's in Sudan. We still all can do something to stop genocide. And that means making as much noise as possible. Governments all around the world understand there's a genocide, but they don't have the political will to do genuine actions. And this is why it's important for normal people to raise their voice so their governments understand this is a priority. So generating that political will, you don't have to be a human rights expert. You just have to be a human being.
Okay, thank you very much. Natalie?
Yeah, thank you. Closing remarks. I guess to underline what both of the last two closing remarks have said, holding any state accountable for genocide does not start or end in a courtroom in the ICJ. I'm not the only one here. I think everybody, one of the speakers here today, has been campaigning for the situation for Rohingya to be recognized as genocide for a lot longer than before, than when 2017 happened. Yeah, we've all been at it for a really long time, and it hasn't come from nowhere. I myself wrote an article in 2014, co-authored an article called The Slow Burning Genocide of Rohingyas. And on top of that article was just endless events, campaigning to try and move that discourse. And one of the things I wanted to just give a little plug for Shabnam's Protect the Rohingya initiative, because, you know, these kind of things, they do shift the discourse. Once they start moving into the public sphere, then there's a lot more momentum behind the illegal initiatives as well. And, you know, the Black for Rohingya campaign has not only helped to shift international opinion, it's also had a lot of take up the last few years with non-Rohingyas in Myanmar taking it up. And so this kind of, you know, bringing people together just with a very simple message is very important. And on a very last point, I'd like to say what I think is most important about what Tunkin was talking about, the initiative in Argentina. And that's that Tunkin and Brooke, his organization, have managed to really keep ownership over it. And so the court process is not simply about accountability, it's about having Rohingya voices heard in the courtroom, and that kind of very symbolic, important part that plays. So basically, you know, there's so much more to all these legal initiatives than the actual outcome. Thanks.
Thank you very much, Natalie. And thank you for always being available to brainstorm Black for Rohingya every year. Henna, over to you.
I would just like to say that, you know, as you talk to people in Cox's Bazar, these are families, these are human beings, they have dreams, they have hopes, they have aspirations. And the biggest thing that they hold on to is hope. And each of these legal cases give them hope. Every time you put a Black t-shirt on and take a photo of yourself, it reminds them that they're not forgotten, because it can feel like the world has forgotten them. So just remembering that this is a human, another human across the world, and just because of their identity, their faith, they are going through this atrocity. Is sometimes in the numbers and in the legal jargon, we tend to forget that. And as many of you are from the legal profession, some of you might be professors or have a say in curriculum. I really do believe genocide prevention should be a part of every legal curriculum. So learning the ABCDs of genocide, what causes from hate to develop to such a degree that it becomes state policy, is absolutely important for a young legal mind to learn about. So I do hope that that these are some of the lessons that we take from these atrocities.
Thank you very much. So with that, thank you to everyone, and we look forward to your participation and your support in all the different campaigns that the organizations before you are running. And to Ken, we wish you all the best with the case. And thank you again to Wolas for hosting us this afternoon.
Thank you, everyone. Thank you.